Hi, my name is Dan Scharf, and I'm a counsel attorney in the education practice group at Miller Johnson. I recently came here after spending just about 18 years working as an attorney in the U.S. Department of Education's Office for Civil Rights in the Cleveland Regional Office. I investigated complaints, developed findings, negotiated agreements, and conducted mediations. As you are likely aware, for reasons I've been told are completely unrelated to my departure, there is no longer an OCR regional office in Cleveland. There is, however, for now, a regional office in Denver that will be handling complaints that would have been handled by the Cleveland office. What I'd like to discuss in this 5-minute message are some things schools can do to help themselves should they find themselves subject to an OCR investigation, and also maybe a few behaviors that they might be best served to avoid. First, and this one's particularly close to my heart from the work I did at OCR, is to consider mediation. And in the last few years, early mediation, where the mediation is offered even before a school receives a formal notification letter or document request. Mediation is offered a path to simply and efficiently resolve complaints before a school has even had to provide any formal type of response. Mediation is voluntary, and both parties have to opt in. But OCR has a stable of mediators who can run a productive mediation session and also counsel both sides on the finer substantive points of the laws and regulations at issue. Second, if you're aware of a complaint and think there may be a simple fix, don't be afraid of trying to fix the problem immediately if that makes sense for the situation. Often this is the case when there's a failure to implement a 504 plan or an IEP. At OCR, I would see many complaints where once the school received notice of the complaint, they'd cut off communication with the parent or have every response to that family come through counsel. Not only would the underlying problem not get addressed, but there would also be the risk of having an allegation of retaliation tacked on to the initial complaint. I'm not suggesting you shouldn't consult with counsel on these issues and in these cases. You should. But OCR often accepts withdrawals, and especially now with the inevitable delays in processing complaints because of the staffing, self-help could go a long way. Typically, these situations don't improve with time, so a timely solution is often the best solution. A parent or student can typically withdraw their complaint, and when their issue is addressed, they often do. Third, what I want to talk about is what to do when you get a data request from OCR, particularly a really broad one. OCR has just about always been slammed, and is especially so now. And often it's easier for an investigator to ask for everything under the sun and just sort things out later. When there's an overly broad data request, we suggest simply picking up the phone or sending an email to talk to the investigator and see if we could right-size our data production. There's no need to send boxes of data when only a folder is necessary. Fourth, if you didn't resolve the complaint through a mediation or through an administrative closure, there's likely to be interviews. Over the years conducting interviews for OCR, I've seen a wide variety of behaviors from schools and their representatives during the interviews themselves, ranging for what could most generously be considered zealous advocacy to the other extreme, which is basically the school's representative doing who the heck knows what, while their client or school employee is being questioned. Like with many things, neither extreme is really that great or effective. These aren't depositions. Objections don't matter. Being loud doesn't necessarily help things. The investigator from OCR is simply seeking answers to questions to help them formulate their finding. And like any organization, some of the investigators are better at articulating what they're looking for than others. Asking for clarification or even asking questions to try to understand what it is the investigator is getting at, it's not only appropriate, but it can be helpful for everyone. While it may seem like it, OCR is not an adverse party in these matters, and for the vast majority of issues, there is a reasonable path forward. I always felt bad for a school when I saw them wasting tons of time fighting when there was a simple and inevitable solution that just wasn't too heavy a lift. For sure, there are times to fight, but in my experience, those times are exceedingly rare. Usually, the easiest thing to do is just work with the OCR investigator, figure out what that person needs and what it takes to resolve the complaint. Lastly, and I think this goes without saying here in Michigan, but I grew up in New Jersey where people had maybe different sensibilities on how to treat each other, so I'm going to bring this up here. The folks at OCR are just doing their job, and there's often leeway on things like granting extensions for data requests, the tone the investigator takes during interviews, and things like negotiating dates and other non-critical portions of agreements. The nicer you are to them, the more reasonable they're going to be with you. And regardless of whether you're happy or sad about it, the reality is that everyone in Denver is being asked to do roughly 3 times the work that they were doing a few weeks ago, and all for an agency that's on its final mission. So with that, thank you for listening, and please feel free to reach out if you have any questions related to civil rights investigations or otherwise. Thank you.